Good afternoon, everybody. I'm Abigail Scott, and together with Kate Longson, we're going to be speaking to you today about the Animals Act in employers' liability claims. We'll be going through this, which is our third of 3 webinars from Ropeport Chambers relating to the Animals Act, covering these topics today. Points 1 and 2 have been dealt with in some detail by the first 2 webinars by Georgina Kersham and Georgina Crawford, respectively. So we'll be dealing with those briefly, but dealing with sections 2.2c and section 5 in some more detail, looking at the common law and other bases for liability. And then Kate will be taking over and doing some worked examples with you, applying what we've discussed in the earlier slides in practical examples and giving you some evidential and tactical tips for claimants and defendants alike. On screen there, I put some examples of when employees and animals might come into conflict. Every case needs to be decided on its facts, but these are the most common settings in which you'll find yourself facing a claim from an employee as a result of an injury by an animal. But the topic for this webinar, animals and employees, requires us to consider who is an employee. And that's particularly an issue quite often in agricultural and equestrian settings where informal agreements, quid pro quo type agreements are often made between people, or informal agreements which might lend themselves to flexible working. And so on screen there are some factors which might influence whether or not somebody in the eyes of the law is considered to be an employee. They are again, but a few examples, and the earlier webinar, particularly Georgina Crawford's webinar, goes through this in some more detail, and I'd encourage you to go and have a look at that if you want to consider that issue some more. But it's important for us today to consider why employment status matters, and it's because it directly impacts on the extent of the duty that an employer defendant will owe to an employee claimant. That's at the common law, because of course the non-delegable duty only applies to employees. Statutory duties often refer only to employees, and so those are regulations. And also the Animals Act in 2 ways refers to the defendant's or the keeper's servants. That's in the imputation of knowledge and also the available defences. So that's why it's quite important to get a hold of this at an early stage in the case and consider whether or not the claimant's status is actually as an employee or otherwise. Another key distinction in the Act is whether the animal that you're dealing with is dangerous or not. And there's a statutory definition of what a dangerous species is on screen there. Really, there's not that much room for dispute, perhaps around whether something is commonly domesticated, but more often than not, it will be clear if an animal is of a dangerous species or a non-dangerous species. And if it's of a dangerous species, liability is likely to be established because you don't need to prove knowledge. However, knowledge is central to establishing liability under section 2.2, which relates to non-dangerous species. And for the large part, non-dangerous species will be the subject of most of the claims that we come across. Dogs, horses, cattle, they are the prime culprits as a rule, and those fall within section 2.2. You'll see set out there that the section provides for 3 separate criteria that need to be satisfied, and we'll work through those again, A and B, in slightly less detail than C, which deals with knowledge. But before we get there, we need to discuss what a keeper is, and I've put on screen here section 6.3, which, insofar as it's relevant, says that a person is a keeper of an animal if he owns the animal or has it in his possession, and then goes on to deal with heads of household. What's important to note here, though, is that there can be multiple keepers and contemporaneous keepers. So in an employment context, that might be the owner of an equestrian yard, could be a keeper of the animals there, but also the employees, if they're out hacking on the animal, that might well be a keeper as well. And whether or not somebody is a keeper is another area of dispute, and it's something that you need to bottom out at an early stage in a case to identify who might be the appropriate defendant, and also whether or not you have any defence to the question of someone being a keeper. And I've put on screen there the case of Flack and Hudson, which many of you will be aware of. it is possible for one keeper to be held liable to another keeper. In that case, the owner of a horse was liable to the loaner of a horse. The loaner didn't know that the horse had a propensity to be fearful of agricultural machinery, whereas the owner did, and the accident that eventuated led to liability on the owner's part. So looking then in more detail at section 22A, there are two routes to establish liability under 22A. The first is that if you can show the damage is of a kind which the animal, unless restrained, was likely to cause. I've given an example there of Kite and Nap, where an Irish wolfhound who was known to attack people carrying bags attacked a person carrying a bag. That animal, unless restrained, was likely to cause that damage. The second way in which that might be satisfied is to show that the damage is of a kind which, if caused by the animal, was likely to be severe. Now, I've highlighted there the word likely in both routes, and we'll look at that some more, but whilst it's necessary to show that the damage was likely to be severe, it's not actually necessary to show that the damage was severe. So what does likely mean? Well, there is a settled definition of that now. It's reasonably to be expected. It's not more probable than not, and it is an issue of fact. It's not to be assessed with the benefit of hindsight. It's to be assessed as based upon the knowledge available at that time. That, of course, makes it highly dependent on the evidence before the court, and Kate will speak more about the evidence that claimants and defendants alike might wish to have in front of the court. But the fact of the matter is that you shouldn't take for granted that an injury is likely to be severe just because it is severe, or indeed that a particular circumstance, such as somebody falling from a horse, which is bucking or rearing, that is likely to cause severe injury. And I put on screen there on the fifth bullet point the case of Freeman and Turnbull. In those cases, it's worthwhile going and having a look at the very different views that Lord Justices Etherton and Lewison had in relation to whether or not falling from a horse was likely to cause severe injury. It is likely that you're going to need evidence to support the contention that it was or it wasn't. And as I say, Kate will discuss that more in a few minutes. Then when we move to section 22B, again, there are two routes to satisfy this criterion. The criterion requires that the likelihood of the damage or of its being severe was due to characteristics of the animal which either are not normally found in animals of the same species, that goes back to the Kite and Nap case, or are not normally so found except at particular times or in particular circumstances. And a prime example of that is Merva Hady, the horse that escaped from the field in a blind panic and collided with a car. The court saying that there was that was not normal behaviour for a horse except when it was fearful. Now, section 22B does require, just going back to the previous slide, the likelihood of the damage or of its being severe to be due to the characteristics of the animal. And that produces a causal link between the characteristic in question and the damage suffered. So in Merva Hady, as I say, the horse's propensity to bolt, to continue to flee, and to ignore obstacles in its path, that was the characteristic which caused the damage in question. That is to be compared with the case of Schultz and Bull, for example, where the horse escaped from the field. But at the time of the collision with a vehicle in that case, the horse was not panicked. It was not bolting. It was not ignoring obstacles in its path. And so there has to be this direct causal link in order to satisfy 22B. So that's 22A and 22B. We'll focus now more on 22C in the employment context. Noting first of all that 22C requires those characteristics to be known to the keeper or at any time known to a person who at that time had charge of the animal as that keeper's servant. So looking at that then in a slightly more detailed sense, those characteristics is a reference to those characteristics in section 22B. And it follows, following Ford and Seymour Williams, that if under section 22B you're relying on particular times or particular circumstances, it has to be knowledge of those particular times or those particular circumstances. It can't be knowledge of some other factor which might produce the same end result, but not being the particular circumstances that gave rise to the result in this case. It isn't necessary to show that you had knowledge specific to that animal, but you can have knowledge that is specific to the species, and that is sufficient for 2.2c. But in employment, well, in all Animals Act claims, but particularly in employment contexts, actual knowledge is required, and there's only one exception in relation to the employer, and that is that it can be imputed to an employer if two factors are satisfied. First, that there was control of the animal by the employer's servant, and secondly, that the employer's servant had the requisite knowledge of those characteristics at the time. Now, that's important, and it's an important distinction between the Animals Act and common law negligence, because in this example, if we start here, we have an employer whose employees were aware of an animal, a dog, attacking customers. And even though the employer themselves were not aware of the dog's propensity to attack customers, the employee's knowledge was imputed to the employer. That's to be contrasted with this case, where the defendant employee didn't have knowledge. The defendant's employee, who was in charge of the horse in this case, didn't have knowledge. But another employee, who was not in charge of the horse at the time, he did have knowledge. Now, in that case, knowledge was not imputed to the employer. So in short, if the employer has actual knowledge, 2.2c will be satisfied. If the employer doesn't have actual knowledge, but the employee in charge of the animal does, 2.2c will be satisfied. But if neither the employer nor the employee in charge of the animal has the requisite knowledge, then 2.2c will not be satisfied. And that's the case even if another employee had sufficient knowledge, if they were not in charge of the animal. So then we look at how is actual knowledge established or shown not to have existed. Well, known propensity is an obvious one. Here you'll see the sign on the right. A known propensity to attack the postman or indeed other animals is something that is clear evidence of somebody having knowledge. Reports made to the keeper by anybody, behavioural assessments or veterinary records can be very enlightening, or indeed if there's nothing in them, it can be quite damaging to a claimant's case. Warnings or advising caution, well, they're there for a reason, and so it's probably because there's some concern around the animal's behaviour. And equally, precautionary measures, muzzles, strong bits, standing martingales, they're used for a reason. And also the claimant themselves, either they'll have knowledge of tendencies of the animal or they won't, and that will be to the benefit of the claimant or the defendant, as the case may be. But as I said at the outset of this webinar, it's necessary to consider every case individually and consider what factors, what pieces of evidence may well establish knowledge or indeed show that there was no knowledge, that this was something that couldn't have been predicted. Moving then to the statutory defences, I've set out section 5 on screen here. Essentially 3 defences on the face of the Act. There's one that is akin to contributory negligence, that the damage was due wholly to the fault of the person suffering it. That under subsection 2, the person voluntarily accepted the risk, or under 3, an exception that typically relates to guard animals, guard dogs. But an important distinction where employee claimants are concerned is section 6, subsection 5, where despite however much somebody might enjoy their job and enjoy working with this particular animal, if that person is injured by the animal, the employer cannot say that the claimant voluntarily accepted the risk. So going back to the previous slide, subsection 2 of section 5 falls away in an employment context. That is not available to an employer. And so now we see why it's so central to determine whether or not the claimant was an employee at the time of the incident. There are clear policy reasons behind section 6.5. An employee can't necessarily turn down instructions from their employer. And so it's right that that voluntary acceptance of risk isn't available. But it does just show why we need to be so careful, both as claimants and as defendants, when we're appraising a case or a defence, to assess employment status. Touching briefly on the first of those statutory defences in section 5, that the damage is due wholly to the fault of the person suffering it. Essentially, the court can apportion damage according to who's to blame entirely or partially, and it might well act as a complete defence for a defendant in the right case. So, for example, in the employers and animals context, you might find that the claimant employee may well have been more experienced than the defendant themselves, but their actions fell far short of what might reasonably be expected of them as somebody with that level of experience and that level of training. Or they might have ignored the express instruction of their employer, or they might have provoked the animal into attacking them or performing the behaviour which resulted in their injury. So if we looked at the Animals Act, we're going to look at negligence insofar as that's informed by EL regulations, but you mustn't forget, if you're acting for a claimant, about other potential causes of action. Put them on the screen here: nuisance, trespass, occupiers' liability and breach of contract. And Kate will speak a little bit more about the importance of some of those and how they might apply in certain cases. But the bottom line is, whilst we're only talking today about the Animals Act and common law negligence, you must always have those other causes of action in mind as a claimant. Looking then at the common law in slightly more detail, we'll all be aware of the employer's non-delegable duty. That's a duty to take reasonable care for the employee's reasonable safety. And it's much broader than the liability that's, or the breadth of potential liability under the Animals Act. It relates to things such as the workplace, to equipment, to training, but it's not strict liability. So whilst it's much broader, there are many more hoops for the claimant to pass through in order to succeed. And common features that we see in animals cases: risk assessments and behavioural assessments, they're so often absent, and if they're present, they're so often lacking. Safe systems of work and appropriate equipment, whether that's for the person, the PPE, or whether it's for animal control, the correct muzzles, bits, saddles, etc. But also staff assessments, training and instruction, supervision. All of these factors in the agricultural and equestrian context are often lacking, and as a claimant you'll be wanting to explore that. As a defendant you'll be wanting to establish that these were in place. I've put on screen there 3 separate regulations. These are the ones that are most likely to be relevant. There are other regulations, but for the purposes of animal related injury, these are likely to be the ones. Whilst they don't create civil liability by their breach, they do inform the common law, and so as a claimant you need to have those in mind when you're setting out your case. Whether you're pleading it, you need to have those provisions in mind. And also as a defendant, you're looking at issues of contributory negligence and potentially the volenti defence, the acceptance of risk in appropriate cases. So again, different ways in which the employer's duty in an Animals Act case might come about. I've put them on screen here. There's the reasonable assessment of staff. Have you got the right people? Have you got the right people with the right training and the right qualifications? Are the right people supervising others? In relation to animals, are you taking appropriate histories from the owner? Or if you're buying it and selling it on from the previous owner, have you done a reasonable behavioural assessment upon arrival? If there have been issues with the animal, either prior to it coming into your keep or indeed in your keep, have you noted that? Have those incidents been acted upon? Or if you're for a claimant, has the defendant acted upon them? Have any special measures been put in place, and have they been allocated an appropriate handler? All of these issues are really bread and butter issues if you're working with animals, but so often, as I say, they're lacking. And then reasonable systems of work. This goes much further into issues of assessing the way in which the work is performed, whether or not the correct method of performing that work is enforced, whether the workplace is safe. So in the animals context, again, perhaps handling multiple animals at once or integrating animals, using muzzles at the appropriate time, or riding horses with a bit or bitless. These are all systems of work. And so again, as a claimant or as a defendant, you'll be wanting to find evidence of that either being lacking or established. And I've put on screen here, it's quite an information heavy slide, so I won't go through it in detail, but key distinctions between the Animals Act and the common law. You can see over the left-hand side, there are the 6 different areas in which they do differ. These slides will all be available to you after this webinar, but I'd encourage you to have those differences and distinctions in mind, because it really does highlight why you would plead a case under the Animals Act if it applied, but also at common law. Now I'm going to hand over to Kate, who's going to pick up where I've left off, take you through some worked examples and give you some hints and tips, and then we'll come back for the question and answer at the end.
Thanks very much, Abby. Good afternoon, everybody. My name's Kate Longson, and I'm going to go now through some worked examples with you before I come on to discuss some practical tips and tricks that hopefully you can employ in your cases. So the first worked example is a canine example, Smith and Happy Hounds. The claimant in this case is a mobile dog groomer employed by the defendant. The defendant provides to the claimant a mobile van, work equipment, and also vets customers and solicits customers on behalf of the business. The claimant attends at the house of Mr. and Mrs. Jones to groom their basset hound, Arnold. During the course of the groom, Arnold bites the claimant's face, and it transpires subsequently that Arnold has a history of biting groomers. Now, much in the same way that Abby did with her table, let's go through the relevant considerations here. First of all, is the defendant on the facts of this case even the keeper of Arnold? Well, it's going to be quite fact specific, and you're going to want to delve in a little bit more detail into the circumstances, because if, for instance, Mrs. Jones is still there, she's holding on to Arnold at the time that the groom's being carried out, then probably not. If it's a case that the claimant picks up the dog and shuts the doors of the van on the driveway of the property and the Joneses are kept well out of the way, you might have a better argument as the claimant that the defendant is the keeper. Let's play devil's advocate for a moment and assume that the defendant is the keeper. If so, are sections 22A and 22B satisfied? Well, on what we know, Arnold is probably restrained at the time that the accident takes place. So you're looking at the second limb of 22A, is the damage caused likely to be severe? And when we consider cases like Curtis and Betts, it's likely, I would suggest, that for a relatively large, strong dog like a basset hound, that the damage is indeed likely to be severe. Section 22B will also be relatively readily satisfied here. This is a characteristic which is not normally found in dogs, or not normally found except in particular circumstances. But we know from what we found out later on that Arnold does have a propensity to bite groomers. Is section 22C satisfied? Well, it's probably not satisfied as regards Arnold directly, because we know from the information with which we're provided that neither the claimant and seemingly by extension the employer were aware of this propensity to bite. But it may be satisfied in the Turnbull and Warriner sense, in the wider sense that some dogs don't like being groomed, and as professional groomers, that's something which the defendant would have actual knowledge of. Any defence is available? It's unlikely, isn't it? Section 5.1 defence isn't going to apply here. The damage can't be said to have been wholly caused by the claimant. Contributory negligence, again, unlikely. It would depend on the wider circumstances, but I would suggest that we're not told anything that raises an immediate red flag as regards contributory negligence. What about a claim in negligence then? Well, certainly there's a duty owed to the claimant. We're told that this is an employer-employee relationship. Is there a failure to risk assess? What inquiries were made in advance? We're told that the custom was solicited by the defendant and the customers were vetted by the defendant. Do they have a questionnaire, for instance, that asks whether dogs have had any previous issues with grooming? Have the owners been honest in that questionnaire? You'll all be familiar with the case of Kennedy and Cordia and what that says about risk assessments. And so whether or not there is a proper risk assessment in place is going to be at the forefront of your mind in any negligence case pertaining to animals, in the same way that it would be in any context. What about provision of suitable work equipment or personal protective equipment? Well, it's perhaps difficult to think what work equipment or PPE might be provided which would have prevented this. That might ultimately be a matter for expert evidence when it comes down to it as to whether any PPE could have been provided. Training and qualifications far more likely to be relevant here. Does the claimant have qualifications? Is she an experienced groomer? Would she have been expected to make inquiries as to Arnold's history when she arrived at the premises in circumstances where she hasn't groomed him before? And so contributory negligence in that sense may actually be relevant. And what about Valenti? Unlikely to provide a complete defence here, in my view. Is there any other obvious cause of action to us? What does the claimant's contract say? It may be, for instance, if the claimant were, for example, an apprentice or had done an apprenticeship with the defendant, that there was some contractual clause pertaining to training or experience or supervision, which might have been breached. In a practical sense, it might be that that doesn't add a great deal to the claim in negligence, but it's nevertheless of relevance and worth pleading if it is of relevance. The second case, Black and Hillside Equestrian Centre, is an equestrian example. In this example, the claimant works on the defendant's yard as a rider and groom. The defendant takes horses on a full range of livery packages, including training livery. And one such training livery at the time of this accident is Clive. He's on the yard for training and is in need of exercise. Clive has a reputation on the yard as being a hothead. He can buck when he gets overexcited, and the yard owner is accordingly frightened to ride him. But the claimant, Phoebe Black, is a young but experienced staff member, and she likes to ride him and enjoys hacking him out. On this particular occasion, Clive bucks whilst he's out on a hack, and Phoebe falls off and suffers serious injuries. Applying those same key considerations to this case, we come up with a perhaps different answer. Is the defendant the keeper? Absolutely yes. There can be no doubt about that. If so, are sections 22A and 22B satisfied? We need to consider both of those. Certainly in relation to the book, I would suggest section 22A is satisfied. Abby has set out previous conflicting case law on this, and it's particularly important that you note the case of Lynch and Ed Walker Racing, although in that case the horse span round quickly and threw off the rider rather than having bucked, which is a rather more vigorous and ferocious way of falling off. Section 22B, again, almost certainly going to be satisfied here. We've got a horse that has a propensity to buck, and that characteristic is most certainly known to the keeper. What defences might we have? Well, we don't really know what's caused the buck on this occasion. It may be that the answer is nothing, that it is simply the propensity of the horse rather than any extraneous factor. On the face of it, there's no section 5.2 defence, but we'll come on to talk about the employer-employee relationship at the moment. It's worth noting that the facts of this case are really quite similar to Goldsmith and Patchcart. In that case, the claimant fell off a horse which bucked and which she knew had a propensity to buck, and the defendant successfully defended the claim on the basis of the section 5.2 defence. That, of course, won't be available if we are in an employer-employee relationship here, but there may be a contributory negligence argument here, particularly if there were extraneous circumstances which caused the buck and it wasn't simply the adverse characteristic. In relation to the claim in negligence, again, we certainly have a duty owed to the claimant, but we need to have a look at that in the context of the employer-employee relationship, if there is one. If I go back a slide, you can see there that the description we have is that the claimant works on the defendant's yard as a rider and groom, but we don't know the circumstances on the facts of that relationship. It may be that the claimant was a freelancer, that she was able to swap her work out to other people, that she wasn't on PAYE, etc. And you may be looking at it through that lens as a contractor rather than an employee. Nevertheless, there will need to be a risk assessment in place. There'll also be a question of whether it was reasonable to allow the claimant to ride the horse. We're told that we're dealing with an experienced employee, but a young employee, and it may be that extra control measures needed to be in place, which weren't in place, such as that Clive wasn't to be hacked out at all, or that he should only be hacked out in company, etc. We've got questions here over provision of suitable work equipment and PPE. Was there any tack that could have been deployed that might have ameliorated the risk of booking or the risk of Phoebe falling off? Was she appropriately trained? Did she have any BHS qualifications? And if that were the case, would that alone provide a full defence in circumstances where this horse was known to be particularly volatile? And we've got then the question again of contributory negligence, and Valenti potentially is relevant here in circumstances where clearly there was knowledge on the part of the claimant as to this particularly violent characteristic on the part of the horse. I'd have thought that as the defendant here, one of the things that wants to be at the forefront of your mind is whether there's a possibility of bringing an additional claim for a contribution or even an indemnity. It will often be the case in livery contracts that there is an indemnity clause such that if employees or anybody indeed is hurt by a particular horse, that the owner will be required to have a particular insurance in place for that. And in circumstances where this is a known characteristic of Clive, that may very well be relevant to the defendant and may be the defendant's best prospect in this case of limiting its exposure. So let's move on then to talk about tips and tricks. And I've split these up into claimant and defendant because it stands to reason that there will be somewhat different considerations on both sides. For claimants, it's really important that you establish a case theory from the outset. What is the characteristic upon which you are relying as being causative of the accident? If you have an accident that's occurred, but the characteristic isn't known or the reason for it isn't known, some more delving needs to be done, and it might be appropriate for you to obtain expert evidence before pleading the case so that you can plead the case at its absolute highest. Expert evidence, particularly in a question in agricultural context, is almost certainly going to be required because the burden is on you as the claimant to prove the characteristics and whether they were normal for the species and or to show that the animal's behaviour was reasonably foreseeable. In an employer-employee context, and this perhaps applies across the board, expert evidence may also helpfully tell you what knowledge the keeper should have had, and perhaps more importantly, what knowledge and experience the claimant could have been expected to have based upon their qualifications and training. Lay evidence is also going to be very important, as it is in any claim, particularly if you can get evidence of prior behaviour and indeed the factual circumstances of the accident if they are disputed. Documentary evidence such as veterinary records, training records, personnel and OH records and health and safety documentation are all going to be the cornerstone of the claimant's case, and it's really important to obtain them pre-action. If there are good risk assessments and good training, you might be on the back foot as the claimant, but if, as is unfortunately so often the case, risk assessments are lacking, safe systems of work and method statements aren't set out in writing, that can only help you. And don't forget those alternative causes of action, as Abigail has already set out. It's really important. There may very well be something in the employment contract or something in an occupier's liability situation, for instance, which is invaluable to a claimant. A question that often comes up in Animals Act cases is whether in an employer-employee context where the animal is owned by someone who isn't the employer, so taking both of the worked examples that I've just gone through, the employer is the only person against whom the claim should be brought, or whether there's a good reason to bring a different keeper, owner or occupier into the claim. The most important consideration in that regard is likely to be the prospects of success against that additional person. The employer-employee relationship, as has been set out already, is particularly strong and particularly important when it comes to establishing liability, because you have a non-delegable duty and because that Section 5.2 defence is stripped away. It may be, in fact, that adding an owner into the mix doesn't actually add anything to the claim. And I'd suggest that in the case of the equestrian centre that we've just gone through, that's likely to be the case. All you're going to have, as far as the owner is concerned, is the availability of the Section 5.2 defence, and you're potentially running into difficulty for the reasons set out in Goldsmith and Patchcart. In another case, such as the dog grooming case that we went through, it may be pertinent to bring the owner in, because in fact, if the owner has kept things from the employer about the dog's propensity to bite, you're going to have a good claim against them as well. You'll all be very mindful, I'm sure, of the cost implications, though, of suing 2 or more defendants and not succeeding against one of them. Cartwright and Venduck makes very clear that in those circumstances, unless you can persuade the court to make a costs order as between the defendants, if they were blaming each other, for instance, the damages can end up being depleted by the costs order of the successful defendant. Prior to April 2023, it was only the damages that the defendant could offset their costs against. But now, post-April 2023, CPR 4414 makes it clear that that is costs as well. So it's really important to get it right. And if the case is strongest against the employer and you're looking at best anyway of a situation of joint and several liability, the best thing to do is to sue the employer alone and allow them to bring anybody else that they think is appropriate into the proceedings, so that ultimately, when it comes to the question of costs, you can lay that at their door rather than it being laid at yours. In relation to defendants, you are, again, at an early stage, going to be wanting to look to identify the nature of the duty. And as Abigail set out already, there are 2 really important considerations. There is the claimant an employee, and is the defendant the keeper? If the defendant isn't the keeper, the Animals Act falls away. So that is a really easy way, if you can establish it, to get rid of an Animals Act claim altogether, and then you're into fault-based liability, which is self-evidently easier to defend. Is the claimant an employee? Again, a really important consideration, particularly in the equestrian context, because voluntary acceptance of risk is almost inevitably, in a horse riding case, going to be a relevant consideration. You mustn't take those things for granted, and they need to be scrutinised at an early stage. Consider the claimant's capabilities, risk assessments, training, PPE, exactly the same considerations as for a claimant, only of course as the defendant you're hoping that there are risk assessments in place and that there is good training, provision of PPE and work equipment, etc. But ultimately, it may be, if the documentation is lacking, that you're looking at calling lay or expert evidence in that regard and looking towards a claimant's previous experience as well as any training that's been given to them by your own insured. And don't forget the potential of an indemnity or contribution claim, and you need to be aware of Bullock and Sanderson orders. So let's just talk about that in a little bit more detail. You can bring into the proceedings by CPR Part 20 any additional party that may be liable for the same damage if it's a contribution claim or where there's a contractual indemnity in place. The particulars of the additional claim can be pleaded in much the same way as the particulars of claim. And that can be done within the main proceedings, but it need not be. There's a 2-year limitation period for contribution or indemnity proceedings, and it may very well be that the most sensible thing for you to do, particularly if your own client is banged to rights, is to settle the primary claim and then proceed against an additional defendant for a contribution or indemnity. Beware the Bullock and Sanderson order. I'm sure you'll all be aware of what they are. That is essentially the power of the court to either order that one defendant indemnifies another in respect of costs or pays the other's costs in the proceedings. And they're typically made where you've got one defendant seeking to lay blame at the door of another defendant. So that is, again, another good reason as to why you may want to wait, settle the proceedings, or indeed see the claim out. You might win, you might defeat the claim altogether, rather than bringing a Part 20 additional claim in the course of the main proceedings themselves. Thank you ever so much for listening, everybody. We're going to take a short break now whilst you submit any questions that you may have, and we'll see you very shortly to answer those.